Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about wills. Joining me once again is my co-host Jesse Barrientos. Jesse, how you doing today?
I'm doing fantastic, Dave. How about yourself?
Very good. Great to see you. You're festive.
Well.
You're getting into the holidays early, which is great.
Absolutely.
We'll let the viewers guess which holiday we're talking about here based on your tie and your handkerchiefs. But Jesse, this is a very important topic that we haven't covered, I don't believe, in all the years we've been doing this, and that is wills. What is going to happen with your property, with your children should you die while they're minors?
Right.
Very important what you plan on doing with your estate, and we're going to dive right into that. So let's start with wills. Why is it important to have a plan going forward?
Well, it's important for many reasons. You know, there's different situations, whether or not you have kids, whether or not you don't have kids. It basically is where you want your estate to go. And basically think of your estate as one, I guess, big pie where all of your assets that you have, maybe it's stock, maybe it's your house, maybe it's your bank account, your money market, you know, all those different types of things, you know, where you want it to go when something happens to you. Because if you don't make that decision, then the state, Illinois has a statute of descent, and pretty much that dictates then, if you die, it's called intestate, without a will, then that dictates where those proceeds and where everything else goes. Now, I suppose, you know, when something happens to you, it's really not going to matter a whole lot to you, but for a lot of folks, they want to make sure that they take care of the appropriate people that they think that, you know, they want to take care of.
Right, and I think a good starting point to mention, as you kind of alluded to, is this is Illinois state law.
Right.
It's in the compiled statutes. It's not federal. Each state is different on how they deal with wills and estates, and Illinois has a strict statute. Certain requirements have to be followed for your estate to be carried out under a proper Illinois will. Now, it's not required, correct, that you have a will?
No, you don't. No, you don't need to have a will. That's correct. That's
What does the state have in place for those folks who do not desire to put their desires in writing? What happens if you die without a will?
Well, there's also what they call a small estate affidavit, and I think, as I'm recollecting, I think it's anything less than or up 50. To 5 or so, and it's basically an affidavit that you fill out and you take care of. And you bring it, for example, if somebody passes away and there's a bank account, as long as you file that appropriately and you fill it out and you give them a copy of that, they're going to turn over those funds. Now, you're going to be responsible if you're fudging on it.
Right. I think a lot of people are afraid to contemplate their own death, and that's why they might put off or completely disregard preparing a will. Do you find that in your practice that a lot of people do not have wills and they're not eager to get one, especially not early in life?
Yeah, a lot of people don't. I mean, that's the last thing on their mind, that something's going to happen to them and that they're going to have to worry about these type of things. But it's also very, very important to consider. I mean, as you say, people think about that. I mean, wow, that's a big kick in the teeth there. You know, I mean, the truth is that each moment, even for you viewers at home, this next moment that's ticking away is another moment closer to, you know, it's appointed once for everybody to die here. And so it's one moment closer to that. And it's very important, not only for you, but also for, if you're married, for your spouse, if you have children, for your children. I mean, there's a whole bunch of different scenarios that just depends on your unique situation.
Yeah, well, getting to the studio tonight, I had to cross the 355 and the 290.
Oh.
So I can totally attest to what you're saying, that in a snap of a finger, you could pass off.
That's true.
So, but let's talk about a few real-life examples, okay, Jesse, if you can help our listeners
Sure.
here. Let's talk about a couple that's married with no children. They own all their property together. It's in joint tenancy. They have a house that's in joint tenancy. The bank accounts are in both of their names. Let's say in this scenario, husband passes away in a construction accident, and wife is the survivor. What will happen in this case to all the property? And remember, the house is joint,
Sure.
and the bank accounts are joint. There's no will. What happens here?
I think the folks at home need to know what joint tenancy is. There is a couple of, joint tenancy essentially is joint tenancy with the right of survivorship. So that means if we have a bank account that's in joint tenancy, that means if something happens to me, everything passes to you outside of probate. It goes to you automatically.
One step further, if something doesn't happen to you and it's in joint tenancy, your spouse can get full rights to that account.
Absolutely. You have a right to the undivided whole, essentially, is what it is.
Right.
For married couples with respect to real estate, it's called tenants by the entirety, which is a kind of a form of joint tenancy. It just provides more rights because the parties are married. But essentially, it's the same deal with the house. If you own a house with tenancy by the entirety or joint tenancy with somebody, then and something happens to one person or the other person, the rest of the house then passes to that person, again, outside of probate. No need to go into probate. So in the example that you're talking about, where the bank accounts are in joint tenancy, where the house is in joint tenancy, and money market or anything else is in joint tenancy, then everything is, well, provided that the joint tenant is your spouse, okay?
Right.
We want to make that sure, hey, a lot of things going on, a lot of things could happen. But, provided that, that everything is going to pass outside of probate, it's going to pass to that other spouse. And so there's not really going to be a whole lot of an issue there.
Okay. How about a situation where there are minor children and the spouses own the property together and the two spouses die simultaneously in a car accident while the child is at home being watched by a babysitter?
Well, see, those are the things that you have to look at too, and I'm glad you mentioned that in terms of simultaneously, because obviously if something happens to one spouse, you have the other spouse who is going to naturally retain custody. In Illinois, there's presumption that the natural parents of the children have a right to custody of those children, because I hear a lot of times people come in and maybe they're divorced or maybe they're not really even married, but it's a paternity kind of situation, and they want, if something happens to them, they want guardianship of the child, and we can talk about guardianship in a little bit, to go to somebody else. Well, again, the biological parents generally, as a general rule, are going to have the primary right to have custody of the children.
But in the case I'm citing, where the parents die simultaneously and there's a minor child, if there's no will, now it's the burden of the court to determine who's going to have guardianship. This is where you have to, or you should have, a plan, a will, to designate who you want to be the guardian for your children in the event of both of your deaths, because it could very well happen.
That's
true. As couples go out and about, or they travel, and minor children are at home, you want to have that thought out, because you don't want to spring this on a grandparent. You don't want to spring this on a brother or sister. You want to talk about it and see if they agree and if it would be a good fit before you start naming guardians or successor guardians.
Right.
Is this correct?
And it's really important, again, and that comes down to being able to kind of talk about this as a family, as a cohesive unit here, to see what people want to be able to happen. And a lot of people don't want to, but it's important for you to be able to focus on that, because that could happen. In a situation like that, where both parents are gone, you not only want to be able to appoint a guardian for your minor children, but you also want to be able to appoint a trustee. And when you talk about guardian, there's a guardian of the estate and of the person. When you say guardianship of the person, it means physical of the person. So I'm your physical guardian of your person. Now, when you say that I'm also the guardian of your estate too, it's also of your estate, which is any monies that you have.
Right.
And so if you have a 5-year-old or a 12-year-old or a 14-year-old or anything in between there, right, you want to make sure that, hey, whatever money, for example, insurance proceeds or the equity in the house or stocks or bonds or bank accounts or anything, is going to be able to be put in trust for your children. And also that they're not going to be able to get their little hands on it until until an age that's appropriate, maybe 21, maybe 25, maybe 20, however you feel, but so that their needs are going to be met and they're going to be able to be taken care of. That means their school is going to be paid. That means any expenses that they might need to have, or for example, extracurricular activities or anything, is going to be able to be taken care of out of that trust.
Right. That's why it's so important to have a provision in there that dictates to the trustee what kind of monies they can spend on the child, when can they pull out additional funds, let's say for a private school or things like that. But there's also provisions you could put in where even when the child becomes a certain age, say 18, 21, 25, even 30, where they would get a certain stipend so that they're not given the whole lump sum estate when they become emancipated. So you can kind of put in some protections, kind of almost, deciding in advance how you want things to be handled in your absence.
Sure, you can absolutely set that up too. And so, within the context of the will, you set up a trust, and then there's a trust that's set up that has specific terms on its own as well. And it's important. It's also important too, and we do a lot of what we call crisscross wills, which is a will for the husband and a will for the wife. And basically, they're crisscross. They're almost identical, except that it says, "Hey, listen, if something happens to me, everything goes to you. If you don't survive me, then it goes to cousin Joe and Aunt Judy and all that, and then vice versa."
Crisscross?
Crisscross, exactly.
Okay.
And then also, there's a provision in there. It's very important. Basically, it says that, hey, listen, if a couple dies under circumstances where it's impossible to determine who predeceased whom, then it shall be assumed that the wife predeceased the husband. And the reason for that is so that you don't have two separate estates going on at the same time. Because if there were no such provision, then, hey, it'd be an estate that would be filed with respect to the husband, and it would be a estate that'd be filed with respect to the wife, instead of just the one, because then everything would pass to the other person that was, that you said, okay, well, it'd be presumed that I predeceased her, so everything will pass to her. But again, since everything is pretty much the same, and hey, I want everything to go to my wife, and if something happens to both of us, then it'll go to the people that we want it to. And it's the same thing. Something happens to me, or rather her, it goes to me. And if something happens to both of us, then it goes to the same people that we want to have it. And so it kind of keeps it in sync.
Okay. Let's talk about some legal requirements.
Sure.
The viewers may not know this, but the will must be in writing.
Has to be in writing.
It must be witnessed by two persons who do not have any share or stake in the outcome.
Right, two competent people, and it's very important that you mention that. And I just kind of brought just a very simple will with me, and maybe we'll look at some of the specific provisions in this.
Yes.
But in terms of the execution, it's very important, and it's true. It has to be with two. I always do three, and I do three because I want to make sure, absolutely sure, this is belt and suspenders, that if any of the witnesses are found in the future to be incompetent or there's a problem with it, I've got my fail-safe, I've got my backup. Not only is that true and important, but when it's witnessed, it has to be in front of a notary. And so there's a peculiar provision where everybody has to sign in front of everybody. So let's say we're doing your will, Dave, and you're leaving happily everything to me. That
Sure.
would be, that'd be nice, right?
That's going to happen.
We take Don't worry about it, Dave. Just sign on the line. We'll take care of it. That's the other important little kind of nuance there, too. If and I'm a lawyer, and if I'm doing our will and anything's being left to me, I really shouldn't do it, because there's an appearance of impropriety or an appearance that I've kind of coaxed you, or I have an undue influence over you to do that. So even for our wills, we'd have somebody else.
Well, I don't think you can do one right now anyway, because one of the requirements is the testator has to be of sound mind.
Oh,
I'm just kidding, but that's an important
true
thing.
enough.
The testator,
That's right.
the person making this will, and that's one of the things that the witness are attesting to,
Right.
that the person who made this declaration was of sound mind, knew what they were doing.
Right.
Because you've heard a lot of cases where
Sure.
a child is passing the will underneath the
somebody on the
elderly
deathbed to change everything else. You see
Right.
that all the time.
Right.
I've even had situations where we've been called out to hospitals or senior rest homes, and sometimes what you can do just to assure that is to have it's called videography, I believe, where you have somebody tape the execution of the will, so that there's, that's further proof that everything is, is kosher and is above board there.
And the person might be physically handicapped or not in good physical health,
Sure.
but mentally they're fine. The signature could be an X. It could be whatever they sign, however they sign at that stage in their life, correct?
Right, but they have to know kind of, they've got to know
what they're doing.
They got to know what they're doing and what's going on. So, getting back to the signature provision, everybody has to sign in front of everybody. So we've got the notaries, we've got the witness, and we've got the test, or the person whose will it is who's signing it. So basically, everybody's together in the same room, and everybody's watching everybody. So and generally, what I'll do is in front of everybody, of course I'll get permission too from the client, but because hey, sometimes they don't want people to know what the provisions of the will, and I'll never have somebody who's inheriting in the will sign off on the will as a witness. We won't do that.
Right.
But so usually these people don't have any kind of a stake in it. So we'll go through it and I'll explain it and review it, the terms with the person who's signing the will, and then they'll initial each page, and then they'll sign it in while everybody else is watching, and then the witnesses will sign while everybody else is watching. And of course, the notary, who is watching everybody while they're signing too, and that's very key and that's very important. That's why people think, oh, just send it to me and I'll take. No, it's important to do it the proper way. And again, I usually tack on an extra witness as well, just to make sure.
Yeah, that's how I typically do it as well. And then I'll make sure that I receive a copy unsigned by the testator, but that has the witness information on it, because I don't want multiple originals of this document floating around.
Well, what I usually do is, you've got what they call the blue backs, which is the document folders. They go on the back, and then the original. So we'll fix up the original. But what I'll do is I'll make several copies, and we'll have the copies that are stapled, and it's got to be stapled. We staple them, the 3 times there, because that's very, very important. Because wills have been found to be a problem with them, because they haven't been really stapled. So, and we'll talk about the requirement for filing it. And then I'll also make copies that are not stapled, just so that if somebody, something happens to somebody, that that they can give it to the appropriate people without having to to unstaple it, or without having any other issues.
Sure. Let's talk about some interesting situations where we talked about a married couple earlier, but I think it's important here because this happens a lot, where one of the spouses will make a will and they'll specifically exclude their spouse. Say they'll leave everything to either a child or maybe an organization or something, but they'll specifically exclude the spouse. Maybe the end of life didn't go too well as a couple. There's a topic or an itemization called renouncing the will that I want you to speak of, because this is important. Because in this case, the woman would think for a minute there that she wasn't going to receive anything because she was specifically excluded and everything went somewhere else. She comes to you and says, "What's the deal here?" What do you tell her?
Well, what's going to happen is I'm fairly certain. I have to just to look at the statute to make absolutely certain, but I'm very certain it'd be 2/3 that she would get. Yeah, I think so. Not a third, but 2/3 of the estate, because she is the spouse. You can't really disinherit your spouse. Well, you can try.
You can try.
You can certainly try, because you have situations where, okay, we're married, everything's fine. Now something happens to me, I'm gonna go to the will, and Jessica Rabbit shows up, right?
You can certainly dissipate the assets while you're living.
You sure can.
And kind of move those away from your spouse.
I mean, well, that's a totally different matter.
Right.
But certainly the will can be renounced, and so you're not going to be able to disinherit completely your spouse.
Right, but you can specifically disinherit a child.
You sure can.
Or children.
You can.
But not a spouse.
Right, and then there are also other provisions that you can put in there, for example, and actually that goes more to a trust. We might just touch basically upon a trust in a little bit here, but you can certainly disinherit them. I mean, they can contest the will, but then it gets into all different kinds of things, and whether or not the person was competent, of sound will and mind, whether or not the witnesses were competent. And
you're also alluding to a situation where there's multiple children and only one child is receiving the benefit under the will.
Sure.
Because of that trickery. You know what happens a lot, Jesse? One child might take care of the elder parent.
Exactly.
And be the primary caretaker, where the other children are kind of not part of it.
Right.
And somehow that living parent gets convinced that maybe those children who aren't coming around as often shouldn't receive as much. And then there's going to be a contest possibly.
Sure, but that, I mean, you have that, and you know, it's unfortunate, but it's true. You know, nobody wants to take care of mom or dad or anything else. I mean, even, you know, to the point, I mean, you know, it's difficult if somebody needs a certain level of assistance in terms of being bathed and fed and going to the washroom, everything else. You know, that's a full-time job. That's a lot of work. And I tell you what, you give credit to people who are able to handle that themselves rather than to put somebody in a home.
Yeah, sometimes it's a matter of finance.
Sometimes it's a matter of finance.
You just cannot afford it.
Right, but I mean, you know, if somebody's doing that, I mean, hey, you know what? That's true, and especially, you know, if you go down, and it's been a couple of years and everything else. I mean, hey, you know, that is what it is, and you know, you never get a call from little Johnny or little Susie or anything else, and okay, oh well, now that you're dead, okay, you know, everybody shows up, and that's how it typically kind of happens. But it's important too to be able to outline, and I've had that in certain wills where people want to outline their last rites. We don't do that so often, but sometimes people are very specific about that. For example, they want to be buried in accordance with the mandates of the Roman Catholic religion and everything you know, that goes along with that. And so that's important to them to be able to put in there so that people know kind of what those wishes are.
We've talked about real estate, we've talked about children. Can you talk a little bit about specific bequests that could be made in the will?
You can do a lot of requests, and I usually tell people, generally what we do is, let's just take something simple. Again, something happens to me, everything goes to my wife. Okay. However, if she predeceases me, which means she dies before me, then I'm going to give my estate to, let's just say I have 4 children. So to my 4 children, and there's 2 different ways to do that. One is called per capita, equally. One is called per stirpes. Now, what that means is if I'm giving my estate, everything I have, to my children, my 4 children, per stirpes, that means there's 4 parts to the whole, right? Each person gets a quarter, right? So now, if something happens to one of my children, what that means is if they have children, they step up and inherit that quarter share in their place.
Right.
Okay.
Per stirpes literally means by the root.
Right.
So that 4th example there would go to the heirs of that deceased child.
Exactly right. Now, if it were per capita, all right, or you know, equally, then if something were to happen to one of the children, then his share would then go into the pot, and it would be divided between the 3, and so on.
Okay, so you got per stirpes and per capita.
And per capita, and those are very important terms because it means something very, very specific. And your attorney should be able to explain those things to you. Very often people want to do per stirpes, which is, hey, listen, actually, a lot of times they just want to skip over the kids and give it to the grandkids, you know.
Right.
But, you know, they certainly want, if there's an issue or a problem, that, hey, listen, that they'll be able to, you know, the children, you know, the grandchildren will be able to inherit their child's portion, you know, to kind of keep.
And this is something that a testator should review either annually or every couple of years to see what's changed.
Sure.
Maybe there's been another child born. Maybe they'll have to do a codicil, which is an amendment to the will.
Right. But I always do, just so that you know, too. I mean, I always, you know, I favor just, you know, just doing a new will and having, you know, having everything done. Usually, what we put in there is, say, listen, at the time of this writing of my will, I have 4 children, 3 children, 8 children, whatever, and we kind of spell it out. And the other person you're giving stuff to. Also, it's very important if you want somebody to have something, that memento. You know, let's say, Dave, that you really like my cufflinks, and hey, you know, I want to make sure that you have these cufflinks.
All of them.
Oh, well, I don't know.
I don't have enough room.
Over 250 pair. They don't take a whole lot of room, Dave, but I'll tell you what, they're stylish, if nothing else.
You bet.
And so I want to sure, I mean, if that's the case, hey, I want all of my cufflinks to go to Dave Siegel, or I want my cufflinks with the diamond and the gold. I want to describe more. If there's a serial number, I want to describe it to make sure that there's not going to be an issue. I have to tell you, and I've got to tell you folks at home, this is absolutely the truth, okay? Money has a way of making people crazy. Whenever there's money involved, even if it's just a little bit, people aren't going to act the way they should act. People are going to get crazy, even family members, and it's going to be a big mess. I've seen that time and time and time, and it's even when there's not a whole lot of money, and it doesn't make a lot of sense to me, really. But people want this. Oh, hey, I want that. I want the other thing. Well, there's only so much cocktail jewelry that you can wear at a time. All right.
Right.
So it's important though that you want to specify exactly what it is that you're going to give to somebody else.
Okay. I would certainly need the shirts to go along with it because I don't have any French cut shirts.
I don't know, Dave. You're a little bit bigger. You might have to get a bigger shirt. I'm not sure.
Could be. I think before we leave this topic, we just have a few minutes left here.
Sure.
Let's talk about living wills or durable power of attorneys. I want you to touch upon that briefly before we have to go.
That's really important. Durable power of attorney for health care is important, and again, it's a power of attorney. Let's explain to the folks at home. A power of attorney, let's just say, Dave, that I'm going to do your real estate closing, and you're going to be gone, so you execute a power of attorney for the purpose, limited purpose, it could be limited, it could be open-ended, for me to do and to sign just like it was you signing. And so basically a power of attorney, I can do anything that you could do if you were doing it yourself. That's what a power of attorney is, pretty much. It could be broad, it could be limited, it could be narrow just to the point I'm doing a closing, you're buying a property, and I'm going to sign for your name and all that, and we do that quite often, okay? So the power of attorney for healthcare basically is saying if I'm in a situation where I am not aware and I am not competent and maybe I'm in a coma or something else, all right, that I'm saying, hey, listen, there's a few choices on there that either I want you to pull the plug, and for our friends at home, I know we have a couple friends, I don't know, I'm not sure, maybe Mark and Rachel, they probably want to pull each other's plug, but anyway, for the purposes of that, okay, I want you to pull the plug, period. Or if there's any possibility, any hope that there's an inclining of a chance, a ray of sunshine that I might be able to be saved, I want you to take every effort. I want you to stick the tube down my throat. I want you to do whatever you can in order to try and bring me back. Then, I can initial that too. And so, basically, it's to make the person who's going to make that decision for you a little better, because now I've got this. Now, you might have what they commonly refer to as a DNR, do not resuscitate, which is, hey, anything happens to me, leave me the heck alone.
Yeah, and that's a one-page document known as a living will that you also execute, give a copy to your primary physician,
right,
a copy to someone in your family, and keep a copy in your own home.
Right. That's important too. I mean, it's important consideration. I mean, for people to think, hey, listen, do I want to live in that situation? Or, do I want to linger around? Do I want to be a financial burden? Do I want, hey, listen, we've spent all of our life together, and do I want all of our savings to be, I don't want to say squandered, but hey, life is precious. But hey, do I want to do that to my spouse? I mean, it's something for you to be able to think about.
Okay. So just to cap everything up here, a will is an instrument whereby you're directing what's going to happen to your property and or the care of your children and all any specific bequests that you might have.
That's true.
In the event of your demise.
Right.
It's an important thing to have. If you don't have one, there are laws that will kick in, state of Illinois laws.
You're not going to like them.
You're never going to like them as well as if you can decide what you want to do on your own,
right,
which is what a will allow you to do.
Right, and just really, and again, maybe we'll do another show on this in terms of trusts. What'll happen is if you do a trust, everything kind of happens outside of probate. I mean, that's something that you really need to get in contact with an estate attorney. You could call the show, maybe ask us some questions, and we'll be happy to provide some answers for those.
Sounds good. Thank you, Jesse. You've been watching Legal Action. You could reach us at Legal Action TV or questions at legalactiontv.com. Dave Siegel alongside Jesse Variantes. We'll see you next time on Legal Action.